Welcome to the Illinois Divorce Guide podcast, where we break down the complex and emotional process of divorce into manageable, easy-to-understand steps. I'm your host, Greer Howard, and with me is Bobby Buchanan, widely recognized as one of Illinois' top divorce attorneys, offering unmatched insight and experience in family law. Well, welcome back to another episode, and today I am back with Bobby, and we have a conversation that we're going to have over the next 2 episodes, as we're going to be talking about when you have a hearing for temporary time for a parenting plan. Now, Bobby, I got to say, anytime someone goes into a courtroom that's not used to going into a courtroom, it can be pretty intimidating, a little overwhelming. It can feel a little stressful to walk into that environment, especially when you're potentially talking about your kids and your parenting time. So today, why don't we kind of talk about what to expect before and how to get ready so that it goes really well. And then next time we'll talk about kind of the nitty gritty of what exactly happens once you get sworn in. So Bobby, great to be here with you today. Why don't we just kind of start with, parents who are potentially going to go to court for this temporary parenting time hearing? What's kind of the overall that they should expect?
Greer, great to see you and talk about this, because I know that it's not just the parents that are feeling anxious when they go into court. I mean, to be completely transparent, us attorneys feel anxious when we go into court as well, even though we've done it thousands of times, because court is serious and there's consequences to it. And it's a different environment than we're ever in our normal day-to-day. So I think if we could talk through some of this stuff, we can maybe ease some of that anxiety. You can at least have some more context for what to expect, and this can go a little bit more smoothly. Now, what people should kind of just expect overall when they go into court is that there is going to be a certain way that things are done. What you're going to see and hear is going to be different. There's a tendency to kind of read into everything that happens in court and draw certain conclusions about what it means, what it doesn't mean, what it means for the rest of your case. And what we want to be careful with is drawing too many conclusions about what happens in court. Now, for this particular temporary parenting time hearing, a lot of different things could happen. You could go through the entire hearing and the judge could give you a schedule at the end. The judge might stop the hearing in the middle and say, we're a little too early to do this. The judge at the beginning might say, let's try to avoid this hearing altogether. I'd like to talk to the attorneys in the back. So a lot of different things could happen. And this is absolutely something that you should have a lawyer for, because it can be kind of so nuanced and varied. But we'll give you a little bit of a preview today of what's going to happen before the hearing itself.
Okay, so when we talk about the hearing, obviously I'm sure there's some preparation that needs to happen so that when you do get to court, you have everything that you need, that you're prepared, and hopefully you're going to get the outcome you're hoping for. So what are a few things that you should bring that day?
Yeah, so this is something that is going to be very fact specific. And what I mean by that is it's your case, it's your specific situation, and family law is what we call one of the most fact-based areas of law that there is. Your attorney is going to learn exactly what's going on in your situation. Maybe you and your spouse are currently living together, but you need some sort of schedule because of the dynamics. Maybe you recently moved out or your spouse recently moved out. Maybe you've been split up for about 6 months and you're running into some parenting time or some scheduling issues, and that's why you're going in for this hearing. So your attorney is going to learn about all that and then tell you what to bring. The most common things that we might bring to a hearing like this would be a diary or a calendar where you've been writing down when you've had the child, when you haven't, any major issues that have been occurring. And then possibly you might be bringing some text messages, some screenshots that have established what your schedule has been, because there's going to be a lead up to this hearing. There's going to be already established a disagreement somewhere. Like, for example, Your spouse's attorney might be communicating to the court that you've never had any weekends. And you're saying, wait a minute, I've had every other weekend for the last 6 months, and I have some text messages here that can prove it, saying, "Hey, so you're gonna pick up little Bobby or little Billy at school this Friday," and your spouse is saying yes. Those sorts of things to establish what the schedule is. So you'll probably bring that stuff in, but your attorney needs to know about all of that stuff before you're bringing it in, because you can't just, this isn't like TV where you can just say, aha, I have this text message that is going to prove you wrong. This is a lot more premeditated and planned out than what you might see on TV.
Yeah, and I wanna mention, so there's probably a lot of text messages potentially going back and forth between the 2 parties, and, would you say that it's important to keep focused on, what you are talking about? Today, we're talking about parenting time, so, you don't really wanna bring every text message that you've ever had. Are you saying, like, let's really focus on the text messages about the switch and who had who, is that right?
Yeah, absolutely. It's going to be those silver bullet text messages that really establish what that schedule has been. And if you're giving over all these text messages for your attorney, one, it's a lot to go through. Two, you're going to be paying for your attorney or their paralegal to go through all of that. And three, at this stage in a case, a judge really doesn't want to get bogged down in he said, she said, you guys calling each other names or the details of your separation or any of that. Like, this is mostly a very high level hearing. A judge wants it to be very child focused, and you want to give the judge what they want, which is really keeping it focused on the child and the nuts and bolts of that schedule.
Yeah, I love when you said, like, sticking to the facts. So, that's such a great thing to remember if you're ever kind of wavering on if it's important information, going back to, is this a fact around what we're talking about? And then knowing, okay, yes, this is relevant, or maybe it's not. What about, is it possible for the couple to decide before they actually show up to the hearing what they want maybe that parenting time to look like? Or do they have to wait and wait for the judge to decide what it's going to be?
That's a great question, because I think there's a lot of people who think once the court case has started, once motions are being filed and hearings are being set, that then all conversation needs to stop between the parties. And it couldn't be further from the truth. You should absolutely, if there's any room for communication between you and your spouse, to continue that dialogue. I mean, this court case is going to come and go. It's going to start and finish. And you and your spouse or your ex-spouse at that time are still going to have to co-parent and figure this out together. So unless there's a court order that you guys need to stop communicating with each other, keep that dialogue going. Keep trying to get that agreement. I mean, at the end of the day, if it has to be used as leverage or a piece of evidence in court, it's not uncommon that an attorney will say, my client has been trying to broker an agreement, trying to communicate, and he's being completely stonewalled by the other side who refuses to talk. That looks good for you and not good for the other side. We want to get away from, winning and losing in this scenario, but we still have to be strategic. But this is both strategic and very practical. Like, get that agreement done before you even get into court, or at least try.
Yeah, I mean, as a divorced person myself, I think it's just so important. If you're able to come up with that schedule between the two ex-spouses, you're going to be so much happier because it's going to work for you. And when it can be really frustrating to have a judge come up with what they think is best for you. If the two can work it out, I think it's always better for the parents and for the child.
Absolutely. I mean, the judge is only, when they do these hearings, these aren't like day-long hearings where the judge is hearing and learning about the intricacies of your schedule and your needs and the child's needs. Like, this hearing might be an hour long, maybe 2 hours long, and then the judge is going to make a ruling, and most likely they're painting with a very broad brush, and they are going to make a schedule that works okay. And there's a very high likelihood that you and your spouse, if you had just been able to talk about it, would have come up with something better, because you understand what works with both of you, or a
For
judge
sure.
doesn't.
No, nobody cares more about your own schedule than yourself.
Absolutely, absolutely.
Well, let's talk a little bit about mindset. You mentioned a little earlier, kind of talking about winning and losing. And, it's so hard to say the win lose when we're talking about a divorce and we're talking about children. So, if we reframe it and say, maybe what would success look like for this hearing? What would you say?
I would say success is leaving the hearing with a schedule that is truly the best for your child in that moment. I mean, this is going to be a temporary schedule. It does set a precedent, it does establish a certain status quo. So we don't want to just be completely hands off with it. But if we're coming into court and we're wanting the judge to stand up and point the finger at the other parent and say, you are a bad parent or you are a bad spouse, then we're coming from it in a completely wrong place. We're going to be disappointed, and we're going to have a tendency to be pointing the finger ourselves in the hearing. We're going to want the judge to hear about all the bad things that our spouse did. And the judge really isn't focused on that. The judge is focused on what is the schedule that works and is in the best interest of the child. So that's really where our mindset has to be.
Yeah, I love that you say that you're really hoping for the best schedule for the child, which kind of leads me to how can you as like go into court and show the judge that you are child focused? Like, are they looking for that to know that a parent is more focused on the child than themselves or just getting back at their ex?
Yeah, absolutely. I mean, it really comes back to being solution focused, being child focused. So instead of pointing that finger, we want to talk about the child. Like, a lot of people make this mistake of using terms like "my child needs this," where it's judges really want to see our child, and you using language like, you know, a judge wants both parties to be facilitating time with the other parent. So if you are just in there with this energy of me, let me get as much time as I can without putting it in the context of why it makes sense for the child to be with you that amount of time, the judge is going to think that it's just about you. So you need to put everything within the context of the child and what's best for them. And if you can't, then you probably should look again at why you really want this schedule, and why, what your motivations are.
hmm I love how you frame that. I want to just like take a minute and say it again that, our child, not my child, but this is our child and what we see is best for our children. And I love that framing because it really does, I think when you say my child, it's so offensive, to the other parent. And so you're not really setting it up to be collaborative. You're kind of, making it separate, and you made this child or children together. So that's a really good thing to think about. I think if you don't take anything else from this conversation, just remembering that it's both of your child or children, and just having that language is so important. And there can be a lot of conflict at home, obviously during a divorce. And, sometimes people want to bring that in. How much does the judge really want to know, or do they want to know about that conflict? And can that get in the way of, maybe what you're actually looking for out of this hearing?
Yeah, you could be listening to this episode and going, well, wait a minute. If I can't point the finger, then how can I let the judge know about this conflict that is happening, and that the environment over at my spouse's house is not in the best interest of my child? Well, if that's the case, if the conflict is at that level, then most likely we shouldn't be doing a hearing of this sort. This is a hearing that's really about the nuts and bolts, and figuring out what kind of temporary schedule is going to work while we dive deeper into this case. If you come to your attorney and say, hey, I'm really concerned about the environment on the other side, or, I'm concerned about the stability that my child has at this other house, the attorney is probably going to advise you to skip a temporary hearing on the parenting schedule and go straight to requesting something like a guardian ad litem. So you have to decide with your attorney, does the conflict rise to that level? Because the more professionals that you get involved, the more you use the court system to try to guide this process, the more complicated, expensive, and out of control it's going to get. So there's conflict in every house. There's more conflict in houses that are split, but does that conflict rise to the level that you and your spouse can't just work out a schedule that's good enough? And that's because there's a tendency to want to weaponize the court. There's a tendency to want to take get vengeance on your spouse because of how things ended in the relationship. Maybe you were the one that split with your spouse. You said, I'm the one, I want a divorce, and now your spouse is getting back at you for that. Well, it's really up to you to try to take the high road here and not turn this and spiral this downwards, so that it's completely out of control. And now you got guardian ad litems, clinical psychologists, and all these other people involved that can get really expensive and not lead to a better result.
So let's do a little hypothetical real quick. So let's say that there's a dad who wants 50-50 custody immediately, but he has moved out. He just moved out of their home. So what would that look like? If they've been in the home, the children have been in the home, the dad moves out and he's like, I want 50-50. What would you say?
Yeah, so if we're representing this dad, the first thing that I'm going to tell my client is you should have talked to me before you moved out, because we don't want to be behind the eight ball. And once you move out without the children, you do lose some leverage. So before we move out, we ideally want to be establishing that schedule. Maybe we're even entering a court order for a 50-50 schedule, and we're laying out in that order that dad's going to move out in 2 weeks, and we've established where he's going to move to, and it's clear that logistically it's going to work out. But we didn't do that, so we're trying to pick up the pieces here. Well, what we're going to be talking to the court about is why this 50-50 schedule is going to be best for the children. We're going to be showing the court the dad has been a major part of the day-to-day caretaking functions of the child. The dad lives close to the school district where the child goes to school. The dad has a flexible work schedule that allows dad to pick up the child from school or from their extracurricular activities. We're really going to focus on why this 50-50 schedule is going to be the least disruptive to the child and help them maintain a close relationship with both parents. And we're also going to be focusing on the fact that mom and dad get along well enough for this to work. I mean, if dad can't be asking for 50-50 schedule and at the same time coming to court and pointing the finger at mom saying she's a horrible mom, or she doesn't communicate well with me, or, and really the court's going to go, wait a minute, how can we do 50-50 if you guys can't even communicate? Like, two parents who want 50-50 have to be able to shoot texts back and forth, letting them know what happened at their parenting time. They have to be able to get on the phone and just have brief transactional calls about what the child needs. And if you can't demonstrate that sort of maturity in court, then a judge is going to say 50-50 is not the right play at this point.
Wow. Okay. So definitely talk to your attorney before you do anything crazy like move out. Yes. Okay. So let's say the day is here and, when you're going to walk in, who are the people you're going to see when you get into the courtroom? And is there how should someone behave? What should their, behavior be like?
Yeah, absolutely. So let's first just start with dress. How should you dress? I think the easiest thing is just honestly like business casual would be fine. I would probably err on the side of a little bit formal, but you don't want to also show up in a tuxedo or something like that. If you only have one suit and it's the suit that you wear to funerals, probably leave that in your closet. It just doesn't come off authentic. So you want to be, nice and tidy and clean and looking good. And when you get to court, most likely, if you have a good attorney, they're going to want to meet with you prior to the court hearing. A lot of people, if you get an attorney who's running from one courtroom to the next, they will feel very overwhelmed when they're waiting for their attorney, and then their attorney rushes in and says, okay, it's time to start. Like, you need time with your attorney. You need to be able to talk through, okay, here's what we're going to do today. Here's what you should expect. So make sure that you are meeting with your attorney at least 15, 20 minutes before the hearing at the courthouse, but your attorney will tell you what to do there. So let's just talk about what to expect at the courthouse. You're going to go to the courthouse. There's going to be security. You may or may not be allowed to bring in your cell phone. So you want to talk to your attorney about that. Once you get to the courtroom itself, if you have a lawyer, then you most likely don't need to check in. Check in is where you go to the clerk. That's usually someone who's sitting to the left or the right of the judge, and they're really managing the schedule of the court that day. Your attorney will be checking in with you. If anyone from the courtroom does address you and say, what are you here for? You can tell them you can say, I have a court date today, and they'll ask you what your name is. And you can say, I have an attorney, they're on their way. You also will most likely see a sheriff in the courtroom. Their job is just to make sure that things are happening in an orderly fashion. And then you will see the judge on the bench. If you don't see the judge on the bench, meaning their seat where they sit at the back of the courtroom or the front of the courtroom, it means they're just on a break, and you just want to wait patiently for them to come back. Make sure your cell phone is off. Make sure that you're not talking to anybody else. That if you are talking to someone, you're stepping out, or that it's a very light whisper and very quick. If you are having conversations in the courtroom, you're going to be called out very quickly, and you do not want to be called out and making a poor first impression.
For sure. For sure. Okay. So what happens if you are waiting in the courtroom and, like you were saying, your attorney's kind of like bebopping from different, courtrooms with different cases, and they're late and your name gets called? What do you do?
Yeah, that can definitely be scary. You basically just need to stand up and walk up to the judge and let the judge know that who you are and that you have an attorney, and request that they pass the case for the attorney. And the judge, once the judge hears that you have an attorney, they'll say, okay, we'll pass the case and wait for your attorney to come. It's nothing to fear. You don't need to speak in some special lawyer language when you talk to the judge. Just be polite and, pretend like you're talking to your boss or, whoever that person is in your life, that you make sure that you're always a little polite and a little formal to, and you'll be just fine. Yep.
All right. Well, Bobby, I think that's all we have time for today. Anything else you want to say before we close out? Next week, we will get into all the details of what actually happens in the hearing. But anything else from today, Bobby?
I would say just be relaxed as you can when you go into the courtroom. It's not going to be life or death when you go in there, and the judge is not going to make any pronouncements as to whether or not you are a good or a bad parent. If you've prepared properly, leave it in the hands of your lawyer to make sure you're ushered through in a way, and just make sure to don't do anything that will actively hurt your case when you're there.
Yeah, all good advice, Bobby. As always, it's great to be here with you. Thank you so much for all of your insight. And we will be back next week where we will be talking about what actually happens during that hearing. So we will see you then.
Thank you for listening to the Illinois Divorce Guide podcast. We hope today's episode gave you clarity and support as you move forward on your journey. If you found this episode helpful, please subscribe, rate, and review us on your favorite podcast platform. Tune in next week for more insights and expert advice on the Illinois Divorce Guide podcast.